Ready? 3, 2, 1, start. The plaintiffs are the appellants before this court. Stop. The plaintiffs had filed a suit for injunction claiming themselves to be in possession of a vacant land and sought for mandatory injunction for removal of construction made by defendants 1, 2, 3. Stop. The plaintiffs claimed that the defendants usurped the possession of the other portion also during the pendency of the suit. Stop. The defendants set up a plea of adverse possession and stated that they had been in possession of the property by putting up construction and enjoying the same for well over the statutory period of 12 years. Stop. The suit was originally decreed and the defendants preferred appeals in CA number 44 of 2012 and Civil Appeal number 21 of 2012. Stop. Both the appeals were allowed, dismissing the suit and finding the plaintiffs as having not proved their title in the property and the relief sought for by them cannot be granted. Stop. The present appeal is against the judgment in CA number 21 of 2012 and the council says that the decree sheet in appeal number 44 has not been prepared as yet and hence the appeal was not brought alongside the present appeal. Stop. The council at the first place points out before me that although the appellants are not having any document of title in relation of the property when they sought for injunction both preventive and mandatory, the very fact that the defendants were making an assertion of right of adverse possession meant that there was an admission of the plaintiff's right. Stop. The court ought to have therefore decreed the suit. Stop. I will hold the arguments to be devoid of legal substance. Stop. A person who sets up a plea of adverse possession cannot be taken as conceding the title of the plaintiffs, and there is no such proposition possible in the way Article 65 of the Limitation Act has been framed. Stop. Article 64 of the Limitation Act applies to a suit for recovery of possession based on previous possession and not on title. Stop. In such an event, the date of dispossession will be the starting point and such a plaintiff who files the suit on previous possession could do so within a period of 12 years. Stop. The point of law is that such a possessory right could be exercised against any person other than the true owner. Stop. Para. Challan was submitted and trial had commenced. Stop. Respondent number 2 approached the Lokayukta Haryana with an application who ordered an inquiry and DIG Crime Branch Gurgaon submitted a report on 14/7/2014 without involving the complainant. Stop. Thereafter the police at the far end of the trial moved an application seeking discharge of respondent number 2. Stop. The additional session judge passed the following order on 5/11/2014. Stop. Reply to discharge application filed. Stop. Since there is an application for discharge of accused Satish, the disposal of which will take long time and accused is in custody since CRM 40383 of 2014 and co-accused are already on bail on furnishing personal bond in the sum of rupees 75,000 with one surety in the like amount to the satisfaction of this court. Stop. There is also no stay of proceedings of discharging the accused applicant. Stop. Over.